1, 2, 3, 4, 5. Here we go. Now I just had criminal hearing number 4. Criminal hearing number 4, and it started out with Weems fighting me. Morgan Briggs from Weems fighting me about the city trying to get a protective order against me, prevent me from looking at the training records, the police policies, and they won. I have Judge Owsley agreed with them that, well, Weems said that since my request was so vague, I just said I wanted to see police policies. That's the merits that we were arguing on here today, was just police policies. So they made the argument very simple. They said that because my request was so vague, just asking for police policies, that all they had to do to argue against that was that all police policies are not to be provided for the public. So you can't add to that argument. They kept it simple. In my request, I just put police policies. I guess I needed to be more specific. But the problem with that was that I couldn't see their table of contents to specify exactly what I wanted to see, so I lost. The police blocked me from seeing police policies, seeing even the table of contents of the police policies. I have to know. But Weems was further supported by Judge Owsley in that he said that he doesn't see how training records are relevant. All right, he doesn't see how some of this information is relevant. So he chose Weems' arguments over mine, over most of it. The only thing that he wouldn't go so far to do was grant the protective order for the city against me on me making FOIA requests against the city. They said Judge Owsley said that sounds like activism, which is beyond the city court's jurisdiction, and he really can't speak on that since he's not really authorized to make those types of decisions, the activist type of decisions. The Weems was trying to prevent activism on my part by trying to get a city judge to grant a protective order against me making public records requests against the city. So I guess you could call that a win on my part, but I lost for my subpoenas trying to get and they did send me these certificates, so some of the police training has been satisfied, but for my arresting officer's disciplinary records, that's not going to be made available. That's not relevant. The police policies are not relevant, because I asked in my motion to have the judge look at the police policies in chambers and pick out what would stand out best in relevance to my case. All right, and Judge Owsley's not going to do it. He's not interested in doing that. So even asking to look at the topics in the police policies is not available. Judge Owsley doesn't want to make it available, and he says a lot of this is not relevant to my case. So it's a loss for me once again, how they perceive my defense. They don't think I could make an acceptable defense by learning about these cop procedures and the backgrounds of these cops. they don't see that as a good defense for me. So I didn't like this. So on Louisiana Code 44.3, it says certain police procedures are exempt from the public. So this city is very close-minded from public scrutiny. Let's see. The next topic, of course, was the motion to suppress evidence. Let's see. And see, I tried to make my arguments in the motion to suppress evidence. Looks like looks like an inmate's being brought into the city court. I've never seen that before. Marshal brought an inmate in orange clothes to the judge's court. The witness statements are erroneous. Judge Owsley said he didn't think that the witness testimony is going to be even used. It's like he's speaking for the prosecutor. He doesn't think even these new videos are going to be used. I wasted 2 hours writing down witness testimony that Judge Owsley doesn't even think I'm going to use. I had to watch it in chambers and write notes. 3 document witness statements. 3 documents. Oh, that's right. Okay, there was 3 documents. It's like I sent the motion to suppress evidence twice. 2 different capacities. One was about this porn on the computer. Evidence is evidence. Okay, this is prosecutor my prosecutor Benjamin's arguments. Evidence is evidence for trial. It's not for making arguments in motions. So the way they set up the system for city courts is you don't want to be in. First of all, you don't want to be in city court. It's such a disaster. It's so unfair. It's so one-sided. So I'm I'm not able to make any arguments that involve any information about the scene because I'm not a lawyer. I try to say, as soon as I said I walked into the library, there was an objection by Prosecutor Benjamin saying that's testimony and I need to be sworn in. So I need a lawyer sitting next to me to say that instead, because then it's not testimony. I can't sit outside myself pro se and I can't say, okay, now this is lawyer Travis talking, or this is defendant Travis talking. I can't separate the two. I can't separate my lawyer side from my defendant side. The judge, the prosecutor, the judge, they won't allow it. So a lawyer could say Travis walked into the library and this happened, but if I say it, it's testimony. It's really an unfair system. It forces you to have to get a lawyer. And I mean that's the logic of the judicial process is that they've used logic to say, okay, if you're going to give testimony as a defendant, then you need to be sworn in and vulnerable to being interviewed, to being questioned by the prosecutor as well. You make your testimony, and then the prosecutor gets a crack at you. But if a lawyer speaks for me, then the prosecutor does not get a crack at that lawyer. So it's really unfair, and it has to be a lawyer, right? You can't just have some stranger come in and read your arguments involving the situation. I could have somebody write the motions and make those scenario arguments. Travis Hines walked into the library and such happened. Somebody else can write those, but I'm actually considered to actually be the one to have written those statements. And Prosecutor Benjamin has objected to my pro se motions because he says I'm introducing evidence into the court, and I can't do that as a non-lawyer, as pro se. I can't even write arguments because I'm not a lawyer and I'm giving testimony. And you know, that really wasn't brought up in Williston, North Dakota. The prosecutors would argue with me about details, about facts, but here they're saying that that's not brought before the courts. It has to be considered. If I'm going to write it or if I'm going to speak it, it has to be, I have to be sworn in, and then it can become a testimony. It can become evidence. And as pro se, this is a very difficult situation. So I need to look for a lawyer. All right, because this is getting this is really getting out of hand. But even with the lawyer, can I win? And I really appreciate Prosecutor Benjamin's advice that I should run. I got to ask him about that one. I should run. I'm like, what? And he's like, you should run. I'm like, if I ran, I'll miss my trial date and then get a warrant for my arrest. But he's telling me I should run, and the judge was just sitting there smiling about it, about that comment. He kind of whispered it. That was interesting. Evidence, okay, nothing says detention is illegal. Has not shown. Yeah, the evidence is weighed by the trier of the facts. The judge is both the jury and the judge. So he's both, and he's preferring to act as more the jury than the judge. I think he prefers to just hear the evidence as the jury before discussing the law. There's just he keeps putting all the motions on the side, saying he won't deny them. He will deny them but not dismiss them. He kept saying that because he's acting more like a jury than a judge. But I mean, yeah, he's trying to act more like a jury than a judge. There's probative or prejudicial. Probative or prejudicial. I think that has to do with the court process in some way. Probative might have to do with the evidence in some way. Yeah, and yeah, once again, I submitted premature motions. Does not believe statutory right to do. There's a statutory right. Jeez, I forget. Deny suppression at this time, but not dismiss. No idea. It's taken illegally. Okay, all right, yeah. Then they talk about this porn on the computer. It's a plain view for the cops. So there's that argument about being plain view on their testimony there. So it is testimony from the police that can be brought into the court. And I will say that I think I saw Officer Davis at the courthouse today, and he looked like he was ready to answer questions. And the only one who's going to answer questions is Officer Davis. There was no Miller. There was no the other one, Favors. There were no librarians. All right, so now this inmate has no handcuffs on, and he's outside. He could book it right now. This is crazy. He's going. Oh, maybe he's set free. Maybe, okay, he's gonna sit in the front seat. I think the judge set him free. He's not in handcuffs. He's just gonna go back to the jail and switch out his clothes at this point. He goes in with handcuffs and comes out without handcuffs with the city marshal. All right. Plain view, a motion to suppress witness statements. Yeah, I stood by suppressing the witness statements, and I was asked why, and I said it's because of it's fruit of the poisonous tree, and that was my argument. And Judge Owsley was like, well, he doesn't even think that these new witness statements will be introduced. They were brought forward, but they're not going to be introduced. He don't believe video will be used. Oh, then we got into the argument about reciprocal evidence. The prosecutor was trying to get me in trouble about not giving reciprocal evidence, and I was like, I don't have anything to give. And then I was like, okay, I gave the court clerks the same thumb drive that Cloyd gave me. But they spent some time. The prosecutor wanted to like say, hey, you know, Travis didn't give me nothing again. We're still at this point. And the judge seemed to take a step back on his former position of saying I have to answer and give incriminating evidence to my prosecutor. Now he's like, okay, he stepped forward. Okay, Judge Owsley stepped forward, saying at the first hearing that only stuff that I intend to bring forward into trial is what I have to give my prosecutor. But at the second hearing, March 7th, he said that I have to just tell the prosecutor everything I'm going to, even if I'm not going to give it, I still have to give it. Even if I'm not going to submit it as evidence, I still have to show Prosecutor Benjamin what I have as evidence and all this. And now Judge Owsley's taken a step back and said, okay, it's what you're going to submit as evidence. So Judge Owsley is kind of going back and forth on me with the submission of evidence, saying even if I'm not going to submit, even if I'm not going to present it at my trial, I still had to give it to my prosecutor. But now he didn't say that today. He took a step back, and so we talked about this Dropbox. I said I emailed, and the prosecutor was like, hey, Travis only like sent me some links, and so Judge Owsley kind of started to sound like he was going to support Prosecutor Benjamin, saying that you got to give more than just links. But then he's like, but if you're going to bring it as evidence for your trial, then only. If you're not, then that's fine. And they asked me like 3 or 4 times, do you plan on introducing evidence? And I'm like, I'm not gonna submit evidence 2 days before my trial like the prosecutor did. And they just asked me several times, okay, are you sure? Are you sure you're not going to submit any evidence? We don't want any surprises or whatever. And I'm like, no. And that's when I said I had the thumb drive from the prosecutor I'm using. So, but they had to like be especially sure on record 5 or 6 times, at least 7, 8. But there was no threats from Judge Owsley here about me not submitting evidence. All right, there were no threats like he did on March 7th. I think he seemed to have walked back, and that's good. It takes pressure off of me. I didn't want to be thrown in jail over this as part of a contempt charge. So you don't have to do anything but sit there. Yeah, and he reiterated that for my Fifth Amendment rights. Everything has to be exchanged, and then yeah, he said once again for trial. I can't bring something in that I didn't present 10 days before the trial. I can contact the witnesses. Okay, yeah. I asked for depositions, and they said that you cannot do depositions as part of a criminal trial. I have the right to confront my accusers at trial. And once again, I saw Officer Davis here today. They this was the trial day, but 2 days ago on Monday it got pushed back because of Prosecutor Benjamin's evidence that he brought at the last minute. Oh, I found these videos that were made January 28th, and I'm just submitting them now, 2 days before the trial. Even Officer Davis showed up. Okay, he wasn't informed that there's not going to be a trial because Prosecutor Benjamin blatantly brought in this surprise evidence that he's been sitting on for 2 months. So when I asked for depositions, I confused criminal with trial. You can have depositions in a civil trial, but you cannot for criminal. You can't interview them twice. That's what I would have done. I mean, I would have been more prepared. They would have been more prepared, but with 2 interviews, but I would have been more prepared too. So it works more in my favor because, I mean, I'm new to this. So they argued against that. Judge Owsley did say you can go and talk to them, and I was like, okay, let me make sure of this. I can't deposition them, but I could go and I can go talk to them. And then that's when Prosecutor Benjamin was like, I don't want you talking with them. You scare them. I scare my witnesses. And we didn't decipher cops, but I mean, they were saying I scare the librarians. He doesn't want me talking with them. And so Judge Owsley did say I could talk with them, but then upon Prosecutor Benjamin's arguments that I scare these librarians, intimidate them, that then Judge Owsley walked back on how I could interview them. If it was a murder or a domestic dispute, domestic abuse case, if I was a defendant, then there's obviously absolutely no way I could interview the victim. All right, but yeah, Judge Owsley was quick to say I could interview them because he recognized that I really have no victims. But then they go into issues with YouTube and the threats that they perceive, and the scare tactics and all of this. And so Judge Owsley walked back on that. And so I was at a loss there. And then that turned into a discussion about the online people who are watching my channel. Judge Owsley was asking me to give a message to ask people to go easy on these guys, all right? He was just called this morning about something. Go easy on there. They're tired of all the contacting, all right? They don't want anybody contacting them. They're asking me to send a message out to everybody and let you know that you got to go easy on these guys, all right? I told them I'd take a neutral stance on that. I'm not telling people what to do. But Judge Owsley's like, you're also not telling people what not to do. and they were going back and forth on that. And that followed, of course, the discussion about me interviewing my witnesses, the witnesses that'll be testifying against me. I can't deposition them, but I could interview them. But it's better to have a lawyer do it, have somebody else do it. And that's the pickle I'm in, because I'm being sidetracked about this testimony thing in court and interviewing witnesses. That's something that a third party needs to be doing. A lawyer needs to be doing. I can't do it myself. Simply because the law says that it interferes with my defense in some way. I can't make testimony, or the prosecutor can then question me if I make statements about facts that happen at the library. So yeah, I created my own problem here because I'm my own attorney. There's uncontrollable people online, and that's what they like to focus on. They don't want to focus on experts, people who may know more than these guys who have titles. These guys have titles, but they only want to accept information from people who also have titles. But I mean, that doesn't always, a title doesn't really talk about competence so much. Maybe you passed a test here and there, but not everybody takes the test. And some people could maybe outperform other people who have taken the test. So it's really it's sad to see, to hear what Judge Owsley and Prosecutor Benjamin say about just common people who take an interest in legal discussions, and for them to focus on the uncontrollable people online. Not everybody's uncontrollable. So there's people in these titled positions who are uncontrollable, who are tyrants. It's like the people without titles are uncontrollable. The people with titles are tyrants, and it's in every aspect of society. a title doesn't necessarily mean that the person is of a good respectful manner. Let's see, one portion of what they do, it's unnecessary. Oh, and then we're arguing about my online presence and how I could make a positive step. I asked Judge Owsley, okay, fine, what do you want me to tell my audience? And he's like, you got to take it upon yourself to do this. But he like went back to that a couple of times, like, you know, you have the power to tell people to leave us alone, pretty much. And I'm like, I'm taking a neutral ground on this because you guys are causing me to be upset. You guys are causing my legal troubles. It's not just me. I didn't approach anybody at the library. I was trying to mind my own business. And then now we're 4 hearings in. This is hearing number 4. The fifth hearing is the trial, unless something comes up. Let's see, a trial, I have the right to cross-examine. But I'm not going to testify. Yeah, I'm handicapped as a pro se defendant for this because the motions I made cannot be read. I cannot make arguments involving any of the facts of the case. You bring up any facts as a pro se, I'm crippled by the prosecutor objecting, saying I should be sworn in, and then he's allowed to he's allowed to question me on the stand, pretty much. So it's a real difficult situation at this point, and it's looking like I really need a lawyer for this trial on April 11th. I'm going to stop here.